You will sit down, or I will have you removed from this courtroom in handcuffs. The gavel strikes marble, once, twice. The sound echoes off walls built a century ago, when courtrooms like this one were designed to make defendants feel small, to make everyone feel small, except the man in the black robe behind the elevated bench. The woman at the defense table does not sit. Judge Winston Mercer has presided over Courtroom 4B for 22 years. He has never, not once, had a public defender refuse a direct order. The gallery holds its breath, 40 people watching something unprecedented unfold. Your Honor, my client has a constitutional right to be heard on this bail motion. The words come measured, calm, without tremor. I'm asking for 60 seconds. Mercer's face flushes crimson. His hand tightens around the gavel like a weapon. Bailiff! The man by the side door moves immediately. Sergeant Vernon Briggs, 20 years of court security, 240 pounds of enforcement. His hand closes around the woman's elbow. Not gentle, not asking. She doesn't flinch, doesn't resist, but she does something no one in this courtroom expects. She smiles. Barely. Just enough. Shock. A circuit court judge just ordered a public defender handcuffed for requesting 60 seconds to speak. Flip. He has no idea that the woman he's about to arrest is the person who will end his career. The court reporter's fingers pause over her machine. In 6 weeks, that transcript will be read aloud in a different courtroom, before a different judge, as evidence in a federal civil rights investigation. But right now, in this moment, all anyone sees is a black woman being escorted toward the side door, while a white judge watches with satisfaction. Let the record reflect, the woman says clearly, her voice carrying across the silent chamber, that I am being held in contempt for citing Florida Rule of Criminal Procedure 3.190. I want that on the record. The bailiff's grip tightens. He pulls her toward the door. And somewhere in the back of the gallery, a man in a gray suit makes a note in a small leather notebook. His name is Marcus Tyndall. He works for the Department of Justice. And he has been waiting 18 months for exactly this moment. If you're new here, hit subscribe. This satisfying story of satisfying justice is just getting started. 6 weeks earlier, the Office of the Attorney General occupied the 3rd floor of a limestone building in Tallahassee that still smelled of fresh paint and new beginnings. Nadine Okafor had been sitting behind the mahogany desk for exactly 93 days when Marcus Tyndall walked through her door with a red folder and a problem. 37%. She looked up from the brief she'd been reviewing. Tyndall was DOJ Civil Rights Division, assigned to the Florida field office for the past 4 years. They had worked together once before, during her federal prosecutor days, on a case involving voter suppression in Duval County. He didn't waste words then. He wasn't wasting them now. 37% of black defendants in Judge Winston Mercer's court receive maximum sentences. He placed the folder on her desk. State average is 19%. His case dismissal rate for indigent defendants is 8%. Private counsel, 42%. Nadine opened the folder. Spreadsheets, charts, 18 months of data compiled by DOJ analysts who specialized in finding patterns that courthouses preferred to keep hidden. 5th Judicial Circuit, she said. Not a question. Marion County. Judge Mercer has been on the bench 22 years. 3 formal complaints to the Judicial Qualifications Commission, all dismissed within 48 hours. Without investigation, without interview. She turned a page. Bail statistics. The numbers told a story of systematic disparity, so consistent it couldn't be coincidence. Who dismissed the complaints? That's the interesting part. Tyndall sat in the chair across from her desk without being invited. They'd known each other too long for formality. The JQC chair received phone calls before each dismissal, from the governor's office. Nadine's hand paused over the spreadsheet. The governor's office. The same office that had confirmed her appointment 3 months ago. The same office that could make her professional life very complicated if she started investigating. Investigating the wrong people. What do you need from me? Cover, authorization, and someone who can get inside that courthouse without triggering suspicion. He leaned forward. Florida's public defender system uses contract attorneys for overflow cases. No one checks backgrounds beyond bar membership. A new face shows up, takes cases, nobody asks questions. You want me to go undercover. I want you to see what we've been documenting for 18 months. The data is overwhelming, but data doesn't testify. Data doesn't capture the moment a judge tells a 19-year-old defendant that he can predict his future based on his zip code. We need someone who can document the pattern from the inside, someone they'll underestimate. Nadine understood what he wasn't saying. Someone they'll underestimate. A black woman. A contract public defender, the kind of person Judge Winston Mercer had spent 22 years treating as furniture. How long? 6 weeks minimum, 8 would be better. Long enough to establish a pattern of judicial misconduct that can't be explained away as isolated incidents. She looked at the folder again. 400 cases, statistical deviations that screamed bias, and buried in the data, the names of real people, real defendants who'd received excessive sentences, denied bail, processed through a system that had decided their guilt before they walked into the courtroom. I'll need cover documentation, bar records that hold up to scrutiny, a background that explains why a prosecutor would switch to defense work. Tyndall smiled for the first time since entering her office. Already prepared, Nadine Brooks, licensed attorney, recent transplant from Jacksonville, taking contract work while building a practice. He pulled a second folder from his briefcase. We've been waiting for the right AG, someone who wouldn't bury the report. She took the folder, opened it, saw her own face staring back from a Florida bar card with a different name. When do I start? Monday. Summit. The Marion County Courthouse sat on a square of dying grass, its limestone facade stained by decades of Florida humidity and institutional neglect. The building had been constructed in 1927, when courthouses were designed to inspire awe. Soaring ceilings, marble floors, bronze fixtures that gleamed in morning light. 97 years later, the awe had faded. The marble was scuffed, the fixtures were tarnished, the air conditioning wheezed like something dying. Nadine walked through the main entrance at 8:47 a.m. on a Monday morning, carrying a briefcase she'd purchased specifically for its unremarkable appearance. Brown leather, scuffed corners, the kind of briefcase that said public defender without requiring words. The metal detector beeped as she passed through. The security officer, young, bored, scrolling through his phone, waved her forward without looking up. "Ma'am, briefcase on the belt." She placed it on the conveyor, watched it disappear into the X-ray machine, waited. "You're good." That was it. No ID check, no questions about her business in the courthouse. The security existed to process volume, not to actually secure anything. She collected her briefcase and walked toward the elevator bank. The public defender's office occupied room 112 in the basement. No windows, fluorescent lights that buzzed at a frequency designed to cause headaches. 3 metal desks pushed against walls covered in water stains that no one had bothered to repair. A woman sat at the front desk, processing paperwork with the mechanical efficiency of someone who'd stopped caring years ago. Court clerk Renata Voss. 43 years old, 14 years in the Marion County court system. According to Marcus's file, she controlled case assignments with an iron grip and a talent for making certain attorneys' lives difficult. New contract attorney? Voss didn't look up. Nadine Brooks. I was told to report here for my first assignment. Sign here. A form slid across the desk. Here. Another form. Initial here. A third. Your cases will be ready by end of day. Judge Mercer's docket is backed up, so expect a heavy load. The pen moved across paper. Nadine signed her temporary name in careful script, each stroke a small act of theater. Any particular cases I should know about? Now Voss looked up. Her eyes were flat, assessing, categorizing. New attorney, black, female. The calculation was visible. Where this person fit in the courthouse hierarchy, how much effort she deserved. You'll figure it out. The words carried dismissal like perfume. Courtroom 4B, 3rd floor. Don't be late. Judge Mercer doesn't tolerate tardiness from defense counsel. The emphasis on defense counsel was deliberate. Prosecution, apparently, operated under different rules. Nadine collected her signed forms and walked toward the elevator. Behind her, she heard Voss pick up the phone, heard the quiet murmur of conversation. Couldn't make out the words, but the tone was clear. Someone was being notified that a new piece had entered the game. The elevator to courtroom level held 6 people comfortably. 8 were crammed inside when Nadine stepped in. Prosecutors in expensive suits, a court reporter clutching her stenography machine, 2 sheriff's deputies discussing last night's football game. A man in a navy suit with gold cufflinks noticed her briefcase. His eyes moved from the scuffed leather to her face, then back to the briefcase. The assessment was quick and unflattering. Public defender? His tone suggested the words tasted bad. Contract attorney, taking overflow cases. Ah, he nodded as if this confirmed something. You should use the stairs, less crowded. No one suggested he use the stairs. No one acknowledged that the suggestion had been made. The elevator continued its slow ascent, while Nadine stood in the corner, cataloging the moment for later documentation. The doors opened on the third floor. The man in the navy suit exited first, walking with the confidence of someone who belonged. Nadine followed at a distance, orienting herself to the hallway geography. Courtroom 4B occupied the prime position. Corner location, largest gallery, best natural light. Judge Mercer's territory. The brass nameplate beside the door gleamed. Honorable Winston T. Mercer, Circuit Court. Outside the courtroom, a cluster of attorneys gathered in the hallway. Private defense bar, based on their suits. The kind of lawyers who charged $400 an hour and knew which judges to take to lunch. At the center of the cluster, a man held court, literally. 3 younger attorneys surrounded him, laughing at something he had said. Dennis Caulfield, 52 years old, 26 years of practice in Marion County. According to Marcus's file, he had a 93% favorable outcome rate in Judge Mercer's courtroom, a number that defied statistical probability unless something other than legal skill was involved. Caulfield noticed her approach. His eyes performed the same calculation Voss's had. New attorney, public defender, black, female, and reached the same conclusion. Well, his smile didn't reach his eyes. Fresh meat for the grinder. The younger attorneys laughed it on cue. Nadine Brooks, she extended her hand. Contract public defender. Caulfield shook it. Brief, perfunctory, the handshake of someone touching something distasteful. Caulfield, word of advice? He didn't wait for her to respond. First rule in Mercer's court, never object more than twice. Second rule, always cite Florida precedent, never federal. Third rule, his smile widened. Actually, forget the rules. Just don't waste His Honor's time, and you might survive the week. I appreciate the guidance. Guidance, he chuckled. That's cute, like you think guidance matters in 4B. He turned back to his circle of admirers, dismissing her as thoroughly as if she'd ceased to exist. Nadine entered the courtroom and took a seat in the back row of the gallery, watching, counting, documenting. The morning docket moved with brutal efficiency. Case after case called, processed, disposed. Prosecutors spoke at length. Defense attorneys, public defenders mostly, got cut off mid-sentence. Bail motions were denied without discussion. Continuance requests were rejected with visible irritation. And through it all, Judge Winston Mercer presided with the authority of a man who had forgotten that his power was borrowed, not owned. Motion denied. Motion denied. Motion denied. The words became a rhythm, a pattern, a system operating exactly as designed. Nadine made notes in a small notebook that looked like case preparation, but served a different purpose. Timestamps, case numbers, rulings, demographics of defendants, everything documented, everything preserved. By noon, she had counted 14 prosecution motions granted. 2 defense motions heard, both denied. The pattern wasn't hidden. It was displayed openly, proudly, like something the courthouse was proud of rather than ashamed. The basement cafeteria smelled of grease and institutional coffee. Nadine sat alone at a table near the vending machines, reviewing the case file that had appeared in her mailbox 2 hours earlier. Case number 24 CF004471. State of Florida versus Darnell Watkins. Burglary, 3rd degree. First offense. The file was thin. 6 pages, arrest report, victim statement, property inventory, booking photo of a 22-year-old black man who looked younger than his years and more frightened than dangerous. She read the arrest report twice. Responding officer noted, suspect was cooperative throughout encounter, no resistance, no threatening behavior. Victim statement indicated, no confrontation occurred. Suspect left premises immediately upon request. All property was recovered. By every metric in the Florida bail schedule, the same schedule posted in every courthouse, theoretically applied uniformly, Darnell Watkins qualified for release on recognizance or minimal bail. First offense, employed, family ties, no violence, no flight risk. But Nadine had watched enough of Judge Mercer's courtroom to know that metrics didn't matter, theory didn't matter. What mattered was who you were and what assumptions the man behind the bench made when he looked at you. Ms. Brooks? She looked up. A woman stood beside her table, holding a lunch tray. Mid-40s, blonde hair professionally styled, suit that cost more than Nadine's monthly car payment. I'm Pamela Lockhart, Senior ADA. The woman sat without being invited. I've heard you're new to the circuit. Word travels fast. Small courthouse. Lockhart's smile was polished, professional, revealing nothing. I wanted to introduce myself, welcome you, offer some advice, attorney to attorney. I appreciate that. Judge Mercer can be particular. The word was chosen carefully. He has a rhythm, a way he likes things done. Attorneys who work with that rhythm tend to have better outcomes for their clients. What does working with the rhythm look like? Lockhart's smile didn't waver. Efficiency, respect for the court's time, understanding that some fights aren't worth fighting. She paused, letting the subtext land. The attorneys who struggle here are usually the ones who think they can change things, who cite federal precedent in state court, who file motions that waste everyone's time. I see. I'm sure you do. Lockhart stood, collecting her tray. We'll probably be opposing counsel at some point. I look forward to working with you. Just remember, the system here works, for everyone, as long as everyone understands their role. She walked away, heels clicking against linoleum. The sound faded into the general noise of the cafeteria. Nadine returned to the Watkins file, read the arrest report a third time, made a note in the margin. Roll, know your place, don't fight. Accept outcomes predetermined by people who've decided your guilt before you enter the courtroom. That was the rhythm Lockhart was describing, the rhythm the entire courthouse operated by. The rhythm that had produced 18 months of statistical anomalies and 3 dismissed complaints and a federal investigation that had been waiting for someone willing to look. The bail hearing for Darnell Watkins was scheduled for 2:15 p.m. Nadine arrived at courtroom 4B at 1:45, taking a seat at the defense table. The gallery filled slowly, family members, other defendants awaiting their turn, the perpetual observers who haunted courtrooms for reasons no one asked about. A woman in her 50s sat in the front row, gray streaked through her hair, hands clasped tightly in her lap. She watched the defense table with the intensity of someone whose entire world depended on what happened in the next hour. Darnell's mother. Had to be. At 2:10, a side door opened. Deputies led defendants into the courtroom, a line of orange jumpsuits and shuffling feet. Darnell Watkins was third in line, 22 years old, slight build, eyes that darted around the courtroom until they found his mother's face. She smiled at him. He tried to smile back. The expression didn't quite land. All rise. Judge Winston Mercer entered through the judicial chamber door, black robe, silver hair, the bearing of a man who had spent 2 decades being obeyed without question. Be seated. Case number 20-4 CF 004471. State versus Watkins. This is a bail hearing. He glanced at the prosecution table. Ms. Lockhart. Your Honor, the state requests bail of $75,000. The defendant is charged with burglary in the 3rd degree. While this is a first offense, the nature of the crime suggests a disregard for property rights that presents a risk of... Objection, Nadine stood. The state is characterizing the offense without foundation. The arrest report indicates full cooperation, no confrontation, and complete recovery of property. Mercer's eyes moved to her. The assessment was quick, dismissive. New face, public defender, black, female, not worth the time. Overruled. Continue, Ms. Lockhart. Lockhart continued. Statistics about burglary recidivism, references to community safety, a narrative constructed to justify excessive bail for a first-time offender whose crime had hurt no one. When she finished, Mercer turned to the defense table. His expression made clear he was fulfilling an obligation, not inviting argument. Counsel? Nadine stood, held the file in her hands, spoke clearly, for the record. Your Honor, the Marion County bail schedule, posted in this courthouse, theoretically applied to all defendants, sets a range of $1,000 to $5,000 for 3rd-degree felonies involving first-time offenders with no violence. Mr. Watkins is employed. He lives with his mother, who is present in the courtroom today. He has no prior record, no history of failure to appear. Every metric supports release on recognizance or minimal bail. Mercer's jaw tightened. The reaction was subtle but visible, a man unaccustomed to public defenders who cited schedules and metrics. "Mr. Watkins," the judge turned to the defendant. "I see from the file that you're unemployed." Darnell's voice was barely audible. "No, sir. I wasn't speaking to you, counsel." Mercer's gaze cut to Nadine. "I was asking the defendant a question. Your Honor, the arrest report clearly indicates employment at—" "Did I ask for your commentary?" The gavel struck once. Sharp, warning. "I'll ask my questions. You'll wait your turn." Nadine felt the gallery's eyes on her, felt the weight of the moment, the choice between compliance and confrontation. The rhythm Lockhart had described, the role she was supposed to play. She remained standing. "Proceed, Your Honor." Mercer turned back to Darnell. "Unemployed, living with your mother, 22 years old." Each fact landed like an accusation. "This is the profile of someone who doesn't take responsibility for his life, Mr. Watkins. Someone who sees shortcuts instead of honest work. Someone who—" "Your Honor," Nadine's voice cut through. "For the record, I have documentation showing Mr. Watkins has been employed for 14 months at—" "Did I give you permission to speak?" Florida Rule of Criminal Procedure 3.131 permits defense counsel to present evidence relevant to bail determination. Mr. Watkins's employment status is directly relevant. The courtroom went silent. Even Lockhart, at the prosecution table, looked surprised. Public defenders didn't cite rules in Judge Mercer's court. Public defenders accepted the rhythm, played their role, understood their place. Mercer's face had gone from irritated to something darker. Something that looked like anger barely contained. "Bail is set at $50,000, cash or bond." The number hung in the air, 50,000. 10 times the maximum recommended. For a first offense. For a cooperative defendant. For a young black man whose only crime had been entering a building he shouldn't have entered and leaving when asked. "Your Honor, I'd like to note for the record that this amount significantly exceeds the county bail schedule for this offense category." Noted, bail stands. The gavel struck. Next case. Behind her, Nadine heard a sound, a single sob, quickly stifled. Darnell's mother, absorbing the news that her son, her employed, cooperative, first-time offender son, would remain in jail unless she could find $50,000 she didn't have. The deputies led Darnell away. He looked back once, finding his mother's face, finding Nadine's. The expression wasn't anger, it was something worse. It was resignation. The look of someone who'd expected exactly this. Who'd known, walking into this courtroom, that justice wasn't something that happened to people like him. If this satisfying story has you hooked, drop a like. It helps more people discover these satisfying stories of satisfying justice. Room 112 was empty when Nadine returned. The other contract attorneys had gone home. The fluorescent lights buzzed overhead, casting their headache-inducing glare across the water-stained walls. She spread 6 case files across the metal desk. 6 bail hearings she'd observed that day. 6 black defendants. 6 bail amounts that exceeded the county schedule by factors of 3 to 10. The notebook came out. Clean page. Column headers. Case number. Defendant name. Charge. Schedule recommendation. Actual bail. Deviation. Judge's comments. The data filled the page like an indictment. Watkins, D. Burglary 3rd. 5K max recommended. 50K actual. Plus 900% deviation. Marshall, T. Assault simple. 2K max. 25K actual oral. Plus 150% gains. R. Theft under 500. ROR recommended. 15K actual. Infinite deviation, and so on. 6 cases. 6 patterns, 6 data points that added to the 18 months Marcus had already compiled. But data was only part of the documentation. The other part, the part that would matter when federal prosecutors built their case, was the qualitative record, what Mercer said, how he said it, the assumptions he voiced aloud, apparently confident that no one was listening, or confident that no one who mattered was listening. This is the profile of someone who doesn't take responsibility for his life. She wrote the quote verbatim. Added timestamp, case number, witness list, 40 people in the gallery, plus the court reporter whose transcript would corroborate. The laptop came next. Not her personal device, the one Marcus had provided, with encrypted partitions and secure transmission protocols. She typed the day's observations, uploaded the data, hit send. Somewhere in Tallahassee, the file would be received, analyzed, added to the growing body of evidence that documented what the Fifth Judicial Circuit had been doing for 2 decades. 1 day down, 41 to go. Day 4 brought the second physical confrontation. Nadine had filed a motion to suppress in case 24 CF 004892, a drug possession charge based on an illegal search. The arresting officer had entered a residence without consent, without warrant, without exigent circumstances. The body camera footage, which she'd subpoenaed and received, showed the violation clearly. The officer knocked once, waited 3 seconds, then opened an unlocked door and walked inside. Textbook Fourth Amendment violation. The kind of case that should have been dismissed on procedural grounds before reaching trial. Motion denied. Judge Mercer didn't look up from his paperwork, didn't acknowledge that the motion existed, didn't pretend to have read the 12 pages of legal argument, the 8 case citations, the attached video evidence. Your Honor, may I be heard on the— You were heard, counsel. Your motion was filed. I read it. Motion denied. But he hadn't read it. Nadine knew this with certainty, because she'd placed a small piece of paper, a bookmark, essentially, on page 1 of the motion. If the folder had been opened, if anyone had reviewed the contents, the bookmark would have shifted or fallen. When the clerk returned the denied motion to her table, the bookmark remained exactly where she'd placed it. Untouched, unread. She made a note, added it to the file. Outside the courtroom, Dennis Caulfield was waiting. You filed another motion to suppress? In Mercer's court? He shook his head with theatrical disappointment. Brooks, I'm starting to think you don't understand how things work here. I understand that my client has constitutional rights. Constitutional rights. The words came with a laugh. You sound like a law professor. This isn't law school. This is Marion County. The Constitution is aspirational here. A nice idea, not a practical reality. Nadine felt the anger rise, pushed it down, kept her voice level. I appreciate your perspective, Mr. Caulfield. I'll continue representing my clients according to my professional judgment. Professional judgment. He stepped closer, into her space. The move was deliberate, physical intimidation dressed as friendly advice. Let me tell you something about professional judgment in this circuit. The attorneys who last, they're the ones who pick their battles, who understand that some fights just waste everyone's time, who don't make enemies of people they can't beat. Is that a threat? It's information. His smile returned, colder now. What you do with it is your choice. But choices have consequences, Brooks. In this courthouse, they have consequences. He walked away, rejoining his cluster of admirers who had watched the exchange from a safe distance. Their laughter followed Nadine down the hallway. The Florida Judicial Qualifications Commission complaint form was 12 pages long. Nadine completed it in triplicate that night. Sitting in her rented apartment on the edge of Marion County, documentation spread across the kitchen table like evidence in an investigation, which it was. Grounds for complaint: pattern of excessive bail inconsistent with county schedule, failure to review defense motions as demonstrated by physical evidence, documented racial disparities in sentencing outcomes, judicial temperament concerns including hostile questioning of defense counsel. She knew the complaint would go nowhere. JQC complaints rarely did, especially against judges with political connections. But filing created a record, a timestamp, official documentation that concerns had been raised through proper channels. More importantly, filing would trigger a response, would show who made phone calls to whom, would demonstrate whether the pattern Marcus had described, complaints dismissed within 48 hours, without investigation, after contact from the governor's office, still held. She submitted the complaint electronically at 9:47 p.m., made a backup copy, stored it in the encrypted drive, then she waited. Seg. The response came faster than expected. 2 days after filing the complaint, Nadine's caseload tripled. 27 new assignments appeared in her mailbox, all in Judge Mercer's court, all scheduled for the same week. She found Renata Voss at the front desk, processing paperwork with her usual mechanical indifference. 27 cases? Nadine kept her voice neutral. That seems like a heavy load for a single week. Voss didn't look up. Heavy docket this month. Everyone's getting extra cases. But when Nadine checked, discreetly, through a sympathetic court reporter who'd been watching her with increasing interest, no other contract attorney had received more than 3 new assignments that week. 27 versus 3. The message was clear. The source was obvious. She accepted all 27 cases, prepared for each one, filed motions knowing they would be denied, made records knowing they would be ignored, built documentation knowing it would eventually matter. Week 3 brought the first genuine physical violence. Case number 24 CF 005234, State versus Thomas Reeves. Assault, simple. The defendant was 19 years old, accused of shoving a man who'd been screaming racial slurs at him outside a convenience store. The victim had a history of similar confrontations. The defendant had no prior record. The prosecution's witness, the man who had been shoved, was testifying. His account contradicted the convenience store's security footage, which showed him advancing aggressively toward the defendant, fists raised, before any contact occurred. Objection, hearsay. Nadine stood. Standard objection. The witness was testifying about what the defendant allegedly said, words she couldn't have heard from her position reviewing the case file. Judge Mercer's face tightened. Overruled. Your Honor, the witness is testifying about statements not made in his presence. That's textbook. I said overruled. She remained standing. I'd like a continuing objection noted for the record, given that movement at her peripheral vision. Sergeant Briggs, the bailiff, stepping away from his position by the side door, moving toward the defense table, moving toward her, his hand closed around her arm. Not the gentle guidance of someone directing traffic. A grip. Fingers pressing into flesh hard enough to leave marks. Ma'am, you need to remain seated when the judge is speaking. Nadine kept her voice steady. I was making a legal objection. I'm permitted to stand. Sit. Down. The words came through clenched teeth. The grip tightened. She could fight. Could cite the rules that permitted defense counsel to stand when making objections. Could make a scene that would end with her in handcuffs and her client without representation. Or she could sit. Document. Add this to the file. She sat. Briggs released her arm, stepped back to his position. The gallery watched in silence, 40 witnesses to an assault that would never be prosecuted because it had been committed by someone wearing a badge in a courtroom where the judge approved. The witness continued testifying. The defendant was convicted, was sentenced to 18 months when the guidelines suggested probation. After court adjourned, Nadine photographed her arm. 4 distinct marks where Briggs's fingers had pressed. Not bruises, not yet, but the beginnings of them. Evidence that would fade within days if not documented immediately. She uploaded the photos to the encrypted drive, added them to the file. The sabotage came on a Thursday. Nadine had prepared a motion for continuance in case 2024 CF 005567, a drug trafficking charge where the prosecution had failed to provide discovery materials required under Brady v. Maryland. Without those materials, she couldn't adequately prepare for trial. The motion was straightforward, legally sound, filed electronically at 4:47 p.m., 13 minutes before the deadline. The filing system confirmed receipt. Timestamp 16:47:32. The next morning, Judge Mercer announced that defense counsel had failed to file her motion by the deadline. This court does not tolerate procedural failures, counsel. His voice carried evident satisfaction. The motion is stricken. Defense counsel is admonished for failing to meet basic filing requirements. Nadine stood. Your Honor, I have a confirmed electronic filing receipt timestamped at 4:47 p.m. yesterday. Well, within the 5 p.m. deadline. The clerk's office has no record of your filing. I have the confirmation on my phone. The clerk's office has no record. Mercer's gavel struck once. Perhaps you should review your technology skills, counsel. This isn't the first time the public defender has claimed technical difficulties to excuse professional failures. At the clerk's station, Renata Voss continued processing paperwork. Her face showed nothing, no reaction, no acknowledgement. The absence of response was itself a confession. Someone had deleted the filing, someone with access to the system, someone who knew exactly which motions to target and when. After court, Nadine approached the clerk's window. I need to verify a filing from yesterday. Case 24 CF Shurifson. Voss looked up. Voss. The expression was careful, controlled. That filing never reached our system, counsel. You should check your submission process. I have a confirmation receipt. Confirmations can be generated without successful upload. It's a known glitch in the system. Voss's smile was thin, triumphant. Perhaps try filing earlier next time. Give yourself margin for error. The conversation was being recorded. Everything in the courthouse was recorded. Security cameras, audio logs, digital trails. Voss knew this, spoke anyway, confident that the system would protect its own. Nadine returned to room 112, logged into the encrypted laptop, pulled up the filing receipt with its timestamp, the confirmation email with its case number, the screen capture she'd taken automatically as part of her documentation protocol. The evidence of the filing existed. The evidence of its deletion would exist in server logs that could be subpoenaed when the time came. The pattern of targeting, her cases specifically, her motions specifically, would become part of the larger case. She added Voss's name to the documentation. Another piece of the puzzle. Another participant in a system that protected itself by destroying anyone who threatened to expose it. The breaking point came on a Tuesday. Case number 24 CF 05891. State versus Marcus Green. Simple assault. The defendant was 19 years old, accused of pushing a store security guard who had detained him for looking suspicious without evidence of theft. The prosecution's case rested on the security guard's testimony. The defense had obtained surveillance footage showing the guard approaching Marcus aggressively, grabbing his arm, and Marcus pushing away in what any reasonable viewer would recognize as defensive instinct. Your Honor, the defense moves to introduce surveillance footage that directly contradicts the prosecution's characterization of events. Judge Mercer glanced at the prosecution table. Lockhart shook her head slightly, a gesture so small it might have been invisible to anyone not watching for it. Motion denied. The footage is not relevant to the charge. Your Honor, the footage shows— I said denied, the gavel struck. Move on, counsel. I request permission to make a proffer for the record. Rule 3.190 permits defense counsel to— I know what the rule says. Mercer's voice rose. Color flooded his face. I've been on this bench for 22 years. I don't need a contract public defender lecturing me about procedure in my own courtroom. I'm not lecturing, Your Honor. I'm citing the rule, for the record, so that when this case is appealed— Appealed? The word came out as a bark of laughter. You think your client can afford an appeal? You think anyone is going to care about this case once it's disposed? Let me explain something to you, counsel. This is my courtroom. What I say goes. What I decide stands. And what you think about rules and records and appeals doesn't matter to anyone except you. The gallery had gone completely silent. Even Lockhart, at the prosecution table, looked uncomfortable, the expression of someone watching a superior officer make a mistake but unable to intervene. Your Honor, I need to preserve the record for my client. That's my obligation under— Your obligation. Mercer's hand reached for the gavel. Your obligation is to respect this court, to follow proper procedure, to not waste my time with motions you know will be denied and arguments you know won't matter. I disagree, Your Honor. My obligation is to my client. You're in contempt. The words fell like a gavel strike themselves. Final, irrevocable. Bailiff, remove defense counsel from this courtroom. Briggs moved immediately, both hands this time, not gentle. Nadine's arms were pulled behind her back before she could react. Metal clicked against her wrists, handcuffs, tight enough to bite. I'm being held in contempt for citing a rule of criminal procedure. She spoke clearly, loudly, ensuring her voice would carry to the court reporter's machine. I want that on the record. Get her out of my courtroom. Mercer's face had gone from red to purple. 4 hours in holding. Maybe that will teach you some respect for this court. They led her out the side door. Past the gallery where 40 people watched in silence. Past Marcus Green, whose case would now proceed without defense counsel present. Past Delia Vance, the court reporter, whose fingers had not stopped moving throughout the entire exchange. The holding cell was concrete and fluorescent light. Metal bench, no windows. The kind of space designed to remind occupants that their comfort was irrelevant to the people who controlled their freedom. Nadine sat with her back against the wall, hands still cuffed behind her, counting minutes, documenting details in her mind that she would transfer to the encrypted file once released. Time in custody, ongoing. Charge, contempt of court. Precipitating event. Citing Florida Rule of Criminal Procedure 3.190, witnesses, 40-plus gallery members, 1 court reporter, 2 bailiffs, 1 ADA. Physical evidence, handcuff marks on wrists, 4 hours, 240 minutes. 14,400 seconds to contemplate the system she was documenting and the cost of documenting it. At minute 217, footsteps approached, heavy, deliberate. Sergeant Briggs appeared at the cell door. His expression mixed satisfaction with something else. Curiosity, maybe. The look of someone examining an animal that had behaved unexpectedly. "You're being released." Judge Mercer decided 4 hours was sufficient. He unlocked the door, removed the handcuffs. His movements were professional now, careful. The awareness that cameras existed, that everything was potentially recorded. "Your personal effects are at the front desk. You're free to go." Nadine rubbed her wrists. The marks were visible, red lines where metal had pressed against skin for 4 hours. Evidence that would photograph clearly. "Thank you." She collected her briefcase, her phone, her dignity, walked through the precinct lobby without looking back, stepped into Marion County afternoon heat that felt like freedom despite the humidity. The car was parked 3 blocks away, in a lot she'd chosen specifically because it wasn't monitored by courthouse cameras. She sat behind the wheel for 5 minutes, breathing slowly, processing the last 4 hours. Then she began documenting, photos of her wrists, voice memo describing the arrest, the cell, the release, text message to Marcus, Phase 1 complete, contempt on record, physical evidence secured. His response came within seconds. Acknowledged, continue as planned. You have 48 hours before JQC dismissal timeline triggers. 48 hours. The same window Marcus had described for the previous complaints. If the pattern held, her JQC filing would be dismissed without investigation within 2 days. And when it was dismissed, the documentation would show not just what Mercer had done, but who had protected him from consequences. The phone calls, the political connections, the system that kept bad judges on benches, because removing them required admitting the system had failed. She started the car, drove back to her apartment, continued building the case that would eventually destroy Judge Winston Mercer's career, assuming she survived long enough to present it. The next morning, Renata Voss greeted her at the clerk's window with a smile that didn't reach her eyes. "Ms. Brooks, I heard about yesterday. Such an unfortunate misunderstanding. Misunderstanding. Judge Mercer can be passionate about courtroom decorum. I'm sure he didn't mean any permanent harm." The smile widened. "Your cases for today are ready. 14 hearings, all in Judge Mercer's court. 14. Down from the 27 she'd been assigned earlier, but still far more than any other contract attorney." The message was clear. They were watching, testing, waiting to see if she would break. Nadine collected the files, returned to room 112, prepared for 14 hearings she knew would go badly, in a courtroom where she knew she wasn't welcome, before a judge who had demonstrated he would use physical force to silence her. Some battles weren't worth fighting, Caulfield had said. Some fights just wasted everyone's time. But some fights mattered. Some fights created records that couldn't be erased. Some fights documented patterns that would eventually become evidence in federal courtrooms, where different judges presided. Judges who believed that constitutional rights applied to everyone, not just people with expensive lawyers. She opened the first file, Case 24 CF 6014, State versus Jamal Washington. Drug possession, first offense, black defendant, young, poor. The profile that guaranteed maximum consequences in Judge Winston Mercer's court. 14 hearings, 14 opportunities to document, 14 pieces of evidence in a case that was building towards something the courthouse couldn't yet see. The emergency came at the end of week 5, case number 2024 CF 006127, State versus Terrence Mitchell, armed robbery. The charge was serious. A first-degree felony carrying potential life sentence. But the evidence was circumstantial at best. Nadine had reviewed the file for hours. The prosecution's case rested on eyewitness identification. A single witness who'd picked Terrence from a photo array 3 weeks after the crime. No physical evidence linked him to the scene. No weapon had been recovered. His alibi witnesses, 2 co-workers who had been with him during the time of the robbery, had never been interviewed by police. "Your Honor, the defense moves for a continuance to locate and depose alibi witnesses who can establish." Denied. The defense moves to exclude the eyewitness identification on grounds that the photo array was suggestive and denied. The defense requests funding for an expert witness to testify about the unreliability of eyewitness identification under the conditions present in this. Denied, 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 Mercer's voice carried theatrical exhaustion. Ms. Brooks, are you going to make any motions I might actually grant? Or is this entire hearing going to be an exercise in wasting the court's time? Nadine stood straighter, met his eyes. Your Honor, my client faces life imprisonment. He has the right to present a defense. He has the right to challenge the evidence against him. He has the right to due process under the 6th and 14th Amendments. Those rights don't disappear because the court finds them inconvenient. The gallery went silent. Even Mercer seemed momentarily shocked. The look of someone so accustomed to obedience that defiance registered as incomprehensible. Trial begins Monday. His voice had gone quiet, dangerous. Your client will be present. You will be present. And you will conduct yourself according to proper courtroom procedure, or you will find yourself in contempt again. Do I make myself clear? Crystal clear, Your Honor. Good. Dismissed. She gathered her files, walked out of the courtroom, found Marcus Tyndall waiting in the hallway, leaning against the wall as if he had been there all along. We need to talk. The diner was 40 miles outside Marion County, vinyl booths cracked by decades of use. Coffee that tasted like motor oil filtered through regret. The kind of place where no one asked questions because no one wanted answers. Marcus sat across from her, nursing a cup of the terrible coffee. You have enough. The contempt citation alone establishes retaliation. The bail data is overwhelming. The filing deletion can be proven through server logs. We can move now. Nadine shook her head. Not yet. Why? Because Mercer isn't operating alone. Someone dismissed my JQC complaint in 36 hours. No investigation. No interview. Just gone. She pulled out her phone, showed him the notification email. That doesn't happen without a phone call, without someone with influence saying, make this go away. The governor's office. That's what your files suggest. But suggestion isn't proof. If we move now, we remove one judge. He becomes a scapegoat. The system that protected him survives. The next Winston Mercer is already being groomed somewhere. Marcus studied her face. The assessment was thorough, professional. The look of someone evaluating not just her argument, but her judgment, her limits, her willingness to continue. The Mitchell case, life imprisonment on circumstantial evidence. If you can't get a continuance, can't exclude the eyewitness, can't get expert funding, he'll be convicted. Maximum sentence. Another young black man fed into the system. And you're willing to let that happen? To preserve the larger investigation? The question hung in the air, the same question she'd been asking herself since the Mitchell file landed on her desk. I'm not willing to let it happen. I'm trying to prevent it. But if I can't, if the system railroads another innocent person, then that becomes part of the documentation, part of the pattern, part of the evidence that eventually dismantles the whole structure instead of just removing one piece. Marcus nodded slowly. You sound like a prosecutor. I was a prosecutor for 12 years. I know how these cases get built. I know what evidence matters. And I know that moving too early just gives them a chance to regroup, to explain away isolated incidents, to sacrifice the obvious bad actor while protecting everyone who enabled him. How much longer? 1 week. The Mitchell trial will demonstrate the pattern in real time. After that, we have enough to file with the chief judge directly. Skip the JQC entirely. Go straight to the evidence. He considered this. Weighted against 18 months of work, thousands of hours of analysis, hundreds of documented violations. 1 week, then we move regardless. Agreed. He finished his coffee, made a face that suggested the taste hadn't improved since the last sip. Counselor, for what it's worth, you're doing exactly what we hoped you'd do. Most people in your position would have revealed themselves after the first contempt citation. Most people in my position haven't been waiting their entire career for a chance to tear down a system like this. She said it quietly, without drama, a statement of fact rather than declaration of intent. Marcus nodded again, stood, left money on the table for coffee neither of them had enjoyed. 1 week. Be careful. They know something's wrong. They don't know what yet, but they're watching. Let them watch. He left first. She waited 10 minutes, then followed. Separate cars, separate routes, the protocols of an investigation that was about to enter its final phase. Sure. Behind her in the diner, at a booth she hadn't noticed, Dennis Caulfield folded his newspaper and signaled for the check. He'd arrived 30 minutes before she had watched the entire conversation without hearing the words. But he'd seen enough. The body language, the deference, the way the man in the gray suit had addressed her, not as a contract public defender begging for guidance, but as an equal. A colleague, someone who outranked him. He paid in cash, left no trace of his presence. Some information was worth more than money. Some information could reshape power structures, protect valuable arrangements, ensure that the people who mattered continued to matter. Caulfield had been in Marion County for 26 years, had watched attorneys come and go, had learned to read the signs of trouble before trouble became crisis. And the woman who called herself Nadine Brooks was trouble, the kind of trouble that could bring down judges, expose arrangements, destroy careers carefully built over decades. He pulled out his phone, dialed a number from memory. "We need to talk about the new public defender. There's something she's not telling us." The satisfying, next satisfying part is dropping tomorrow. Subscribe so you don't miss the satisfying moment the judge realizes his biggest mistake. The subpoena arrived Friday morning. Nadine found it in her mailbox at room 112, tucked between case files like an afterthought. Official court document. Case number redacted. Subject, records request pursuant to Florida Statute 107. Someone had filed a public records request for all documents related to complaints filed against Judge Winston Mercer in the past 5 years. Someone was looking. Someone wanted to know who was asking questions. She read the subpoena twice. Noted the attorney of record, Dennis Caulfield. Noted the requesting party, Marion County Judicial Preservation Society, an organization that didn't exist in any state registry she could find. The timing wasn't coincidental. 3 days after her conversation with Marcus, 2 days before the Mitchell trial, someone had seen them together. Someone had connected dots. The question was whether they knew what she was or just suspected that something was wrong. She photographed the subpoena, uploaded it to the encrypted drive, added it to the timeline. The investigation was accelerating, the endgame approaching, but first, she had to survive Monday's trial. The weekend passed in preparation. Nadine spent 40 hours reviewing the Mitchell file, building a defense strategy for a trial she knew was designed to fail. The prosecution had stacked the deck. Favorable judge, circumstantial evidence presented as certainty, alibi witnesses deliberately not interviewed. But trials were unpredictable. Witnesses could surprise. Evidence could shift. The same system that protected bad actors also contained people who believed in justice. Court reporters who documented everything. Jurors who asked hard questions. Occasional judges who remembered why they'd taken the oath. She prepared for every contingency, drafted cross-examination questions, researched the eyewitness's background, found 3 prior cases where he'd provided identification testimony, 3 cases where the identified defendant was later exonerated through DNA evidence. A pattern. Another pattern. The kind of evidence that should matter to a jury, even if the judge pretended it didn't exist. Monday morning arrived with the inevitability of sunrise. Nadine dressed in her most professional suit, the one she'd brought from Tallahassee, the one that didn't look like a public defender's wardrobe. Today, she needed every advantage. The courthouse was the same limestone facade, the same dying grass, the same wheezing air conditioning. But something had shifted. The security officers looked at her differently. The hallway conversations paused as she passed. Word had spread. The public defender who talked back, who cited rules, who didn't know her place. She walked into courtroom 4B at 8:45, took her position at the defense table, waited. Judge Winston Mercer entered at 9 exactly. His eyes found her immediately. The expression was controlled, professional, but beneath it, something burned. Anticipation. The look of a man who had decided that today would be the day this particular problem was solved. State of Florida versus Terrence Mitchell. Trial proceedings. Counsel, are you ready? The defense is ready, Your Honor. Prosecution? Pamela Lockhart stood. Ready, Your Honor. Then let's begin. The first blow came within minutes. Your Honor, the defense renews its motion to exclude the eyewitness identification on grounds that... Motion denied. We addressed this Friday. Move on. The defense requests permission to introduce evidence of the witness's prior identification testimony in cases where denied, not relevant to the current proceeding. Your Honor, Florida Evidence Code 90.405 permits evidence of specific instances of conduct when character is an essential element. I'm familiar with the Evidence Code, counsel. Motion denied. Final warning. Move on or face contempt. 3 motions, 3 denials, less than 5 minutes. The trial was proceeding exactly as designed. The prosecution's case unfolded with mechanical efficiency. The eyewitness took the stand, described seeing Terrence Mitchell flee the scene with a weapon. His testimony was confident, detailed, rehearsed, the product of weeks of preparation with Lockhart's team. Nadine's cross-examination was methodical, careful, building toward a single devastating point. Mr. Wallace, you testified that you identified the defendant from a photo array 3 weeks after the incident. Is that correct? Yes. How many photos were in the array? 6. And you identified Mr. Mitchell immediately? Pretty quickly, yes. Did the detective administering the array give you any indication which photo might be the suspect? No. Did he say anything before you made your selection? A pause, barely perceptible. He might have said something like, "Take your time, we want to get the right guy." The right guy. Singular, as if there was 1 correct answer and 5 wrong ones. Objection. Lockhart rose. Counsel is characterizing the witness's testimony. Sustained. Move on, Ms. Brooks. Nadine moved on, but the point had landed. Some of the jurors were frowning, thinking, questioning. Mr. Wallace, this isn't the first time you've provided eyewitness identification in a criminal case, is it? I don't remember. Let me refresh your memory. In 2019, you identified a defendant in a robbery case, State versus Franklin. Do you remember that case? Maybe. I don't know. The defendant in that case was later exonerated through DNA evidence. The actual perpetrator was a different man, one who looked nothing like the person you identified. Objection. Lockhart's voice was sharp. This is not relevant to the current proceeding and is highly prejudicial. Your Honor, this goes directly to the reliability of the witness's identification. Sustained. The jury will disregard counsel's last question. Ms. Brooks, I warned you about relevance. Final warning. The jury would disregard nothing. The seed had been planted, the doubt introduced, but it might not be enough. In a system designed to convict, might never be enough. The prosecution rested at 11:47. The defense called its only witness, Terrence Mitchell himself, testifying in his own defense because he had no other choice. He was young, scared. His voice shook as he described where he'd been during the robbery, at work, with coworkers who could confirm his presence. Coworkers who had never been interviewed because the police had decided he was guilty before the investigation began. Lockhart's cross-examination was brutal, efficient, designed to make Terrence look like a liar without proving he actually was. Mr. Mitchell, if you were at work during the robbery, why didn't you tell the police this when you were arrested? I did tell them. They didn't listen. They didn't listen. You're claiming the police ignored an alibi that would have cleared you? I'm telling you what happened. Or you're telling this jury a story you've had 3 months to rehearse. Objection, argumentative, overruled. The witness may answer. Terrence's face crumpled, the look of a man watching his future disappear. I didn't do this. I was at work. My coworkers can tell you. If anyone had just asked them, no further questions. The jury filed out for deliberation at 2:15. Nadine sat at the defense table, watching them go, calculating the odds. The eyewitness testimony was problematic but not destroyed. The alibi was unsupported by other witnesses. The judge's rulings had systematically prevented the defense from mounting an effective case. In a fair trial, there might be reasonable doubt. In Judge Mercer's courtroom, reasonable doubt was a luxury defendants couldn't afford. They returned at 4:47. 2.5 hours of deliberation, not long enough for a complex case. Exactly long enough for a jury that had been given permission not to think too hard. Has the jury reached a verdict? We have, Your Honor. The foreman's voice was steady. The paper shook slightly in his hands. On the charge of armed robbery in the first degree, we find the defendant guilty. Terrence Mitchell's mother screamed. A single sound, raw and primal, that echoed off the marble walls and died against the indifference of the court. Deputies moved to restrain her. Someone called for order. The gavel struck repeatedly, but the sound couldn't erase what had just happened. Sentencing will be scheduled for next month. Mercer's voice carried satisfaction barely concealed. The defendant is remanded to custody pending sentencing. They led Terrence away. His eyes found Nadine's as he passed. Not accusation, not anger, just the hollow recognition of someone who had known all along how this would end, who had walked into a system designed to process people like him and had been processed exactly as designed. She gathered her files, walked out of the court's room, found Marcus Tyndall waiting in the hallway again. "Tomorrow," she said. "We file tomorrow." What changed? Nothing changed. That's the point. Nothing ever changes, not until someone forces it to change. She looked back at the courtroom doors. "I've been documenting patterns for 6 weeks. Today I watched a pattern destroy a young man's life in real time. I'm done documenting. It's time to act." Marcus nodded. "Emergency motion, Chief Judge Blackwood, 9 a.m.? I'll be there." She walked out of the courthouse, past the security checkpoint, past the dying grass and limestone facade, into afternoon heat that felt like something other than freedom now. Behind her, the Marion County Courthouse stood unchanged. Same building, same system, same patterns that had been operating for decades. But tomorrow, those patterns would face something they hadn't encountered before: accountability. And the woman who called herself Nadine Brooks would finally reveal who she really was. The emergency motion was filed at 9:58 p.m. that night. Caption: Emergency motion for recusal and judicial inquiry. 37 pages, Exhibits A through R, every receipt, every transcript, every data point collected over 6 weeks of systematic documentation. And on page 1, a correction to the record that would echo through every courthouse in Florida. Counsel of record for this motion, Nadine Okafor, Attorney General of the state of Florida. The morning arrived cold and gray, unusual for Florida in autumn. Chief Judge Eleanor Blackwood's courtroom occupied the administrative wing of the courthouse, smaller than the trial courts, designed for motions and hearings rather than juries. No gallery seating, no spectator rows, just 2 counsel tables facing an elevated bench where decisions were made without audience. Nadine arrived at 8:32 a.m. She wore a different suit today, charcoal gray, tailored, the kind of suit that announced authority rather than requested permission. The weathered briefcase was gone. In its place, a leather attaché with the seal of the Florida Attorney General's office embossed in gold. The transformation was deliberate, complete. The woman who walked into this courtroom was not Nadine Brooks, contract public defender. She was Nadine Okafor, chief law enforcement officer of the state of Florida. Marcus Tyndall waited in the hallway outside, gray suit, DOJ credentials visible on a lanyard around his neck, no longer hiding. There inside, Mercer, Lockhart, Briggs. Caulfield came as Mercer's counsel. He handed her a folder. Updated numbers from overnight analysis. The pattern is even worse than we documented. She opened the folder, scanned the summary page. 3 years of data compressed into statistics that told a story of systematic discrimination so blatant it bordered on confession. Any contact from the governor's office? Radio silence. They know something's happening. They're waiting to see which way to jump. Good, let them wait. She closed the folder, tucked it under her arm, walked toward the courtroom door. "Nadine," Marcus's voice stopped her. "Whatever happens in there, you did this right, by the book. No shortcuts, no compromises. The evidence speaks for itself. The evidence always speaks for itself. The question is whether anyone listens." She pushed through the door. If you watched part 1, you know what's coming. Subscribe now. This is the satisfying moment we've been building toward. The courtroom was smaller than she remembered, or maybe it just felt smaller with the weight of what was about to happen pressing against the walls. Judge Winston Mercer sat at the respondent's table, Dennis Caulfield beside him. Mercer wore a suit instead of robes, the first time Nadine had seen him without the black fabric that symbolized his authority. He looked diminished somehow, older. The transformation from judge to defendant had already begun, even if he didn't know it yet. Pamela Lockhart sat behind them, separated by the bar rail, not a party to the proceedings, but present, watching, calculating. Sergeant Vernon Briggs stood near the side door, in uniform but clearly uncomfortable. His usual position was guarding judges, not being summoned to answer for his conduct toward attorneys. Chief Judge Eleanor Blackwood entered through the judicial chamber's door, 63 years old, 24 years on the bench. African-American woman who had climbed through a system designed to exclude her and had reached a position where she could finally hold that system accountable. All rise. Everyone stood, the ritual of respect that courtrooms demanded, even when the people in them had forgotten what respect meant. Be seated. This is an emergency hearing on a motion filed last evening. Blackwood adjusted her reading glasses, looked at the caption page. Motion for recusal and judicial inquiry filed by... She paused, read the name again, looked up at Nadine. The recognition was immediate. The AG's office had sent Blackwood a courtesy notification at 6 a.m. as protocol required. She knew who was standing at the movant's table. She just hadn't expected to see her in person. Attorney General Okafor, you're appearing personally on this motion? I am, Your Honor. Across the room, Judge Mercer's face underwent a transformation. Confusion first, the name didn't register. Then slow recognition as he connected the face at the movant's table with the woman he had held in contempt 6 days ago. Then something else, something that looked like the beginning of fear. This is... His voice cracked. He cleared his throat, started again. This is highly irregular. The Attorney General doesn't appear personally on judicial conduct matters. This should be handled through the JQC. Judge Mercer, Blackwood's tone carried warning. You're not presiding here. You're responding to a motion. Counsel will speak for you if you have objections. Caulfield stood. His usual confidence had eroded overnight. The man who had mocked Nadine in courthouse hallways now faced her across a courtroom where the power dynamic had inverted completely. Your Honor, the defense... He stopped, corrected himself. The respondent requests a continuance to review the motion and prepare an adequate response. We received this filing less than 12 hours ago. The motion is 37 pages with 18 exhibits, Blackwood said. I've reviewed it in full. The evidence presented establishes grounds for immediate action under Florida Judicial Conduct, Canon 3. Your client will have opportunity to respond to specific allegations, but a continuance is not warranted for emergency proceedings. She turned to Nadine. Attorney General Okafor, you may proceed. Nadine stood, walked to the center of the courtroom, faced the bench directly. Your Honor, for the past 6 weeks, I have been conducting an undercover investigation into civil rights violations in the 5th Judicial Circuit, coordinated with the Department of Justice Civil Rights Division. That investigation has documented a systematic pattern of discrimination, procedural violations, and abuse of judicial authority centered in Courtroom 4B, Judge Winston Mercer's court. Behind her, she heard Mercer shift in his chair, heard Caulfield whisper something urgent, ignored both. The evidence we've compiled includes statistical analysis of bail decisions, sentencing outcomes, and case dispositions over a 3-year period. It includes documented instances of judicial retaliation against defense counsel who challenged improper rulings. It includes physical evidence of assault by court personnel acting under Judge Mercer's direction. And it includes testimony from court staff who witnessed the pattern and were afraid to report it. She paused, let the words settle. I'm going to present that evidence now. When I'm finished, I will ask this court to take immediate action to protect the citizens of Marion County from continued violations of their constitutional rights. Blackwood nodded. Proceed. The first exhibit was statistical. Your Honor, Exhibit A is a comprehensive analysis of bail decisions in Judge Mercer's court from January 21 through October 24. The analysis was conducted by DOJ statistical experts using methodology that has been validated in 17 federal civil rights investigations. Nadine activated the courtroom's display screen. Numbers appeared, charts, graphs, the cold mathematics of discrimination. During this period, Judge Mercer presided over 473 bail hearings involving black defendants and 391 hearings involving white defendants. For comparable offenses, same charge category, same criminal history, same flight risk indicators, black defendants received bail amounts averaging 68% higher than white defendants. The chart showed the disparity in stark visual terms. 2 lines that should have tracked together, separated by a gap that widened over time. The state average disparity is 11%. Judge Mercer's disparity is 68%. That's 6 times the state average. The statistical probability of this occurring by chance is less than 1 in 10,000. Caulfield rose. Objection. Statistical analysis can be manipulated to show any conclusion the analyst wants. Without reviewing the underlying methodology, The methodology is included in Exhibit A, Appendix 3, Nadine said. It's the same methodology the Department of Justice used in Ferguson, in Baltimore, in Chicago. If counsel wants to challenge it, he's welcome to hire his own experts. But the numbers are the numbers. Blackwood looked at Caulfield. Objection noted. Continue, Attorney General. Onang, the second exhibit was documentary. Your Honor, Exhibit B is a compilation of court transcripts from Judge Mercer's courtroom, documenting statements made from the bench that reveal explicit bias against indigent defendants and defendants of color. She read from the transcript. The words filled the courtroom like accusations. October 14th, 23, case number 23 CF 003892. Quote, Mr. Washington, I've seen defendants like you before. Same neighborhood, same excuses, same trajectory. The pattern is predictable. End quote. The defendant was 17 years old. First offense. He received maximum sentence. She turned to the next page. March 7th, 24, case number 24 CF 01247. Quote, This court doesn't have time for defendants who can't afford private counsel and then expect the same level of consideration. End quote. The defendant's public defender had requested additional time to prepare for trial. The request was denied. The defendant was convicted and sentenced to 12 years. Another page. September 23, 2024. Case number 24 CF 005891. Quote, Let me explain something to you, counsel. This is my courtroom. What I say goes. What I decide stands. And what you think about rules and records and appeals doesn't matter to anyone except you. End quote. She looked up from the transcript. That last quote was directed at me, 6 days ago, immediately before Judge Mercer held me in contempt for citing Florida Rule of Criminal Procedure 3.190 and ordered me physically removed from the courtroom in handcuffs. The silence that followed was absolute. Even Blackwood, who had read the motion, seemed affected by hearing the words spoken aloud in a courtroom where they could echo against marble walls. The third exhibit was physical. Your Honor, I'd like to introduce Exhibit C, photographs taken on September 24, 2020, Psalm 24, approximately 4 hours after my release from courthouse holding. The screen displayed images of Nadine's wrists, red marks where handcuffs had pressed into skin, the beginnings of bruises that had fully formed by the following morning. These injuries were caused by Sergeant Vernon Briggs, acting on Judge Mercer's direct order. The handcuffs were applied with unnecessary force. They remained in place for 4 hours and 12 minutes. At no point was I offered medical attention or given the opportunity to have the restraints loosened. She turned toward Briggs. He stood against the wall, face pale, uniform suddenly looking less like authority and more like costume. Sergeant Briggs has been a court bailiff for 20 years. In that time, he has developed a pattern of using physical force against defense attorneys who displease Judge Mercer. I have documented 3 such incidents during my 6 weeks in this courthouse. I have affidavits from 2 other attorneys describing similar treatment. Briggs's hand moved toward his belt, an instinctive gesture, reaching for authority he no longer possessed. The assault on my person constitutes a violation of 42 U.S.C. Section 1983, deprivation of equis and monarchism of reprivation of rights under color of law. The Department of Justice has opened a criminal investigation. Sergeant Briggs will have opportunity to respond to those charges through appropriate channels. This is where the satisfying receipts, satisfying start piling up. If you're enjoying satisfying justice, satisfying served, satisfying cold, drop a like. It helps more people find these satisfying stories. The fourth exhibit was the most damaging. Your Honor, Exhibit D is a collection of emails obtained through public records request under Florida Statute 119-907. These emails document a pattern of ex parte communication between Judge Mercer and Assistant District Attorney Pamela Lockhart, communication that violated Florida Judicial Conduct, Canon 3B7, which prohibits judges from initiating or considering ex parte contacts concerning pending matters. Behind Nadine, Lockhart stood abruptly. I object to the characterization of, Ms. Lockhart, you're not a party to this proceeding. Blackwood's voice cut through the interruption. Sit down. You'll have opportunity to respond through appropriate channels. Lockhart sat. Her face had gone from professional composure to something raw. the look of someone watching a carefully constructed career begin to collapse. Nadine continued. I'll read selected excerpts. Exhibit D, page 4. Email dated July 12, 24. From ADA Lockhart to Judge Mercer. Subject line, Williams case scheduling. Body text, Winston, can we get the Williams case moved to your docket? Martinez is asking too many questions about the evidence chain. Thanks, Pam. She turned the page. Reply from Judge Mercer, same day, done. Have the clerk file the transfer order. Tell Martinez to focus on cases he can actually win. Another page. Exhibit D, page 7. Email dated August 3rd, 24. From ADA Lockhart. The Morrison defense attorney is pushing for a continuance. Any way to deny without it looking retaliatory? Reply from Judge Mercer. I'll handle it, but you owe me lunch at the club. The emails continued, page after page of casual corruption. Prosecutors and judges coordinating outcomes before trials began. Defense attorneys targeted for professional destruction. Defendants processed through a system that had decided their guilt before they walked through courthouse doors. Your Honor, these emails establish not an isolated incident but a systematic pattern of coordination between Judge Mercer and the Marion County District Attorney's Office. Cases were assigned based on desired outcomes rather than proper rotation. Defense motions were denied based on prosecution requests rather than legal merit. The fundamental right to a fair trial, guaranteed by the Sixth Amendment, guaranteed by the Florida Constitution, was systematically denied to hundreds of defendants over a period of years. She closed the exhibit folder, and when complaints were filed, when attorneys tried to report what they'd witnessed, those complaints were dismissed without investigation, without interview. Within 48 hours of filing, she paused. This was the most dangerous part of the evidence, the part that implicated people beyond this courtroom. Your Honor, I have evidence suggesting that those dismissals occurred after contact from the governor's office. I am not presenting that evidence today because the investigation is ongoing, but I want this court to understand that Judge Mercer did not operate in isolation. He was protected, enabled. His violations were not secrets. They were features of a system designed to produce specific outcomes for specific populations. Blackwood removed her glasses, rubbed her eyes. The gesture was human, weary, the response of someone confronting the full scope of institutional failure. Attorney General Okafor, what relief are you requesting? 3 things, Your Honor. First, immediate suspension of Judge Winston Mercer from all judicial duties pending formal proceedings before the Florida Judicial Qualifications Commission. Second, referral of Sergeant Vernon Briggs to the State Attorney's Office for Criminal Prosecution under 42 U.S.C. Section 1983. Third, formal notification to the Department of Justice that the state of Florida will cooperate fully with any pattern or practice investigation into the 5th Judicial Circuit. She looked directly at Mercer. Their eyes met across the courtroom. Judge Mercer has presided over this court for 22 years. In that time, he has demonstrated contempt for constitutional rights, contempt for judicial ethics, and contempt for the fundamental principle that all defendants deserve equal treatment under law. His continued presence on the bench represents a clear and present danger to the citizens of Marion County. He must be removed immediately. Caulfield rose for his response. His voice had lost its usual polish. The words came out defensive, scrambling. Your Honor, what we've witnessed today is nothing more than prosecutorial theater. The Attorney General admits she went undercover, that she deceived this court, deceived court staff, deceived Judge Mercer himself about her identity and intentions. Everything she's presented is fruit of that deception. He gestured toward the exhibits. The statistical analysis relies on assumptions that can be challenged. The transcripts are taken out of context. The emails, even if authentic, show nothing more than professional communication between colleagues who work in the same courthouse. And the photographs of alleged injury could have been self-inflicted or caused by any number of factors unrelated to courthouse personnel. His voice gained confidence as he found his footing. What the Attorney General has actually demonstrated is that she doesn't understand how county courthouses operate. She doesn't understand the pressures judges face, the caseloads they manage, the split-second decisions they make hundreds of times per week. She came into this circuit with preconceived conclusions and gathered evidence to support those conclusions. That's not investigation. That's persecution. He turned to face Nadine directly. And I have to question the timing of all this. The Attorney General has been in office for less than 4 months. She's facing political challenges from multiple directions. A high-profile judicial misconduct case would be extremely convenient for someone trying to establish credentials with certain constituencies. Mr. Caulfield, Blackwood's voice cut through, you're approaching territory that has nothing to do with the evidence presented. Confine your response to the substance of the motion. Caulfield's jaw tightened. Your Honor, my client has served this community for 22 years. He has handled thousands of cases. He has been recognized by the Florida Bar, by civic organizations, by elected officials at every level. One attorney's grudge, however powerful that attorney might be, should not be sufficient to destroy a lifetime of public service. He sat down. The defense rested on reputation rather than rebuttal, the last refuge of those who couldn't address the evidence. Blackwood was silent for a long moment. The courtroom waited. I've reviewed the motion and exhibits. I've heard argument from both sides. She looked at Mercer. Judge Mercer, do you wish to make a statement before I rule? Mercer stood, slowly. The movement of a man whose body had absorbed a blow his mind hadn't yet processed. Your Honor, I have served this court faithfully for more than 2 decades. I have made difficult decisions in difficult cases. I have sometimes been strict, perhaps too strict, in maintaining courtroom decorum. But I have never allowed race or economic status to influence my rulings. His voice cracked slightly. He steadied it. The Attorney General came into my courtroom under false pretenses. She provoked confrontations. She deliberately violated procedure to create the appearance of judicial misconduct. What happened to her in my courtroom was the result of her own choices, not my bias. He looked at Nadine. The hatred in his expression was undisguised now, the final dropping of the mask he'd worn for 22 years. I don't know what political agenda motivated this investigation. I don't know why the Attorney General chose to target me specifically, but I know that what happened here today is not justice. It's destruction, and I will fight it with every resource available to me. He sat down. Caulfield put a hand on his shoulder. The gesture was meant to be supportive. It looked more like restraint. Chief Judge Blackwood removed her glasses, set them on the bench, looked at each person in the courtroom in turn. I've been on this bench for 24 years. In that time, I've seen judicial misconduct addressed through proper channels, quiet reprimands, private counseling, the occasional suspension. The system prefers to handle its problems internally, to protect the institution, to maintain public confidence in the judiciary. She paused. But there are limits. There are lines that, once crossed, cannot be addressed through quiet channels. The evidence presented today crosses those lines. She turned to Mercer. Judge Mercer, the statistical analysis alone would justify investigation. A 68% disparity in bail decisions based on race is not strict interpretation of law, it's discrimination. The transcripts corroborate that the numbers reflect actual bias rather than statistical anomaly, and the emails establish a pattern of coordination with prosecutors that violates the most basic principles of judicial independence. Her voice hardened. But what I find most disturbing is not the discrimination itself, it's the contempt, the casual assumption that constitutional rights are inconveniences to be dismissed, the belief that your courtroom is somehow exempt from the rules that govern every other court in this state, the willingness to use physical force against an attorney who cited a rule of procedure. She picked up her gavel. Effective immediately, Judge Winston Mercer is suspended from all judicial duties, pending formal proceedings before the Florida Judicial Qualifications Commission. His cases will be reassigned, his chambers will be secured. He is ordered to have no contact with any court staff, any pending defendant, or any witness identified in the Attorney General's motion. The gavel struck once. Sergeant Vernon Briggs is relieved of his position, pending criminal investigation by the State Attorney's Office and the Department of Justice. He will surrender his badge and weapon before leaving this courthouse. Another strike. This court will formally notify the Florida Bar of potential ethical violations by Assistant District Attorney Pamela Lockhart. Her cases will be reviewed for evidence of improper coordination. She is suspended from courtroom appearances pending that review. A final strike. These proceedings are adjourned. Attorney General Okafor, please coordinate with court administration to ensure smooth transition of Judge Mercer's caseload. This court appreciates the professionalism and restraint you demonstrated during your investigation, Blackwood rose. Everyone stood. She disappeared through the judicial chamber's door without looking back. The silence that followed lasted perhaps 3 seconds. Then Mercer turned to Nadine. You destroyed me. His voice was quiet, shaking. 22 years of service, a lifetime of work. Destroyed because you wanted a headline, because you wanted to prove something. Nadine gathered her exhibits, organized them in her attaché, answered without looking up. Judge Mercer, you destroyed yourself. I just documented it. This isn't over. Caulfield was at Mercer's elbow, trying to guide him toward the exit. We'll appeal. We'll challenge every piece of evidence. You'll do what you need to do. Nadine finally looked at them. And the evidence will remain what it is. 400 defendants received excessive sentences. Hundreds more were denied due process. Careers were destroyed because attorneys challenged your authority. None of that disappears because you hire good lawyers. She walked past them, toward the door, toward whatever came next. Behind her, she heard Mercer's voice, strangled with rage. You have no idea what you've started. The people who protected me, they don't forgive betrayal. They don't forget. She paused at the door, turned back. I'm counting on it. The hallway outside the courtroom had filled with people who had no official reason to be present, but had heard that something significant was happening. Court reporters, clerks, attorneys who had paused between hearings, all watching, all waiting. Marcus met her at the elevator bank. It's done? Suspension ordered. Briggs relieved. Lockhart suspended from courtroom appearances. She pressed the elevator button. The cascade has started. The press is already calling. Somehow word got out. Let it out. Transparency is part of the process. The elevator arrived. They stepped inside. The doors closed on the crowd of watchers, sealing them in temporary privacy. What's next? The JQC will convene emergency proceedings. Mercer's attorneys will file every motion imaginable to delay, suppress, discredit. DOJ will run the pattern or practice investigation. The whole process will take months, maybe years. And the governor's office? Nadine was silent for a moment. The elevator descended. The governor's office is the part we haven't touched yet. The evidence of their involvement is circumstantial. Phone calls that were made but not documented. Complaints dismissed too quickly for normal process. Someone protected Mercer for 22 years. Someone with power. Finding out who, proving it, that's the next investigation. The elevator reached the ground floor. The doors opened. But that's tomorrow's problem. Today we removed a judge who spent 2 decades destroying lives. Today, the system worked. She stepped into the lobby, toward the front doors, toward whatever accountability looked like in a world where accountability was always partial, always incomplete, always just the beginning of something larger. 4 months later, the headlines arrived. Florida Times-Union, former Circuit Judge Mercer faces federal civil rights charges. The article detailed the indictment. 18 counts of deprivation of rights under color of law. 18 U.S.C. Section 242, each count representing a specific defendant whose constitutional rights had been systematically violated, each count carrying potential imprisonment of up to 10 years. Nadine read the article in her office in Tallahassee, the same office where Marcus had first presented the red folder, the same desk where she'd made the decision to go undercover. The journey from that decision to this headline had taken 6 months. In that time, the investigation had expanded, contracted, faced challenges, overcome obstacles. The path to justice, real justice, not the theatrical kind, was never straight. The JQC had formally removed Mercer from the bench 2 months after the emergency hearing. The proceedings had been contentious, his attorneys filing motion after motion, challenging evidence, attacking methodology, claiming procedural violations at every turn. But the evidence held. The transcripts spoke. The emails damned. Removal, not resignation. The distinction mattered. Resigned judges could sometimes resurface in private practice, in consulting, in the networks of power that survived individual accountability. Removed judges carried a mark that followed them forever. But removal wasn't punishment. Removal was just the end of authority. The federal indictment, that was the beginning of consequences. The phone on her desk buzzed, her assistant's voice. Attorney General Marcus Tyndall from DOJ on line 2. She picked up. I saw the news. Marcus's voice carried something she rarely heard from him: satisfaction. 18 counts, federal jurisdiction. This goes to trial. He's looking at 20 years minimum. If it goes to trial, you think he'll plead? I think his attorneys will advise him to plead. The evidence is overwhelming. A jury trial means every piece of documentation becomes public record. Every email, every transcript, every statistical analysis. The smart play is to negotiate, plead to reduce charges, accept whatever sentence the federal prosecutor offers, and hope the story dies down before it consumes everyone else involved. The smart play? Marcus's tone shifted. But Mercer isn't smart. He's proud. He spent 22 years being obeyed, being feared. Pleading guilty means admitting he was wrong. I'm not sure his ego can handle that. Then we'll see him in court. Speaking of court, Lockhart took a deal. Nadine leaned back in her chair. What kind of deal? Bar suspension, 5 years, no admission of wrongdoing, but she agreed to never seek public office or government employment. She's already taken a position at a private firm in Tampa, the soft landing, the system protecting its own. She wasn't important enough to prosecute, but too connected to completely destroy. It was the pattern Nadine had witnessed throughout her career, the system's self-protection instinct. Sacrifice the obvious bad actor, let the enablers slip away, announce reforms that were never implemented, and wait for public attention to move elsewhere. Ann Briggs pled to misdemeanor assault, probation, loss of pension. He's working security at a shopping mall in Ocala. Misdemeanor, the word tasted bitter. He assaulted an attorney in a courtroom. He spent 20 years intimidating defense counsel on a judge's orders. Misdemeanor. The assault on you was the only one with solid documentation. The other incidents, the attorneys were afraid to testify, afraid of retaliation, afraid that even with Mercer gone, the system would find ways to punish them. They're probably right. Probably. Marcus was silent for a moment. But you did what you could, what you set out to do. The pattern is documented. The primary actor is facing federal charges. The enablers are gone or damaged. The DOJ investigation will produce recommendations that might actually be implemented. Might. Might is better than never. Might is better than the alternative. Mercer's still on the bench, still processing defendants, still destroying lives while everyone pretends not to notice. She couldn't argue with that. The alternative had been the status quo. The alternative had been another 20 years of 68% bail disparities and maximum sentences and transcripts full of casual bigotry that no one challenged. What about the governor's connection? Marcus's pause told her everything. The investigation is ongoing. We have circumstantial evidence, phone records showing calls from the governor's office to the JQC chair before each complaint dismissal. But calls aren't crimes. Without recordings, without documents, without someone willing to testify about what was said, the insulation worked. The insulation always works at that level. People like Mercer, people like Lockhart, they're visible, exposed. The people above them know how to maintain distance, how to communicate without leaving traces, how to protect themselves while letting others take the fall. Nadine thought about the anonymous email she'd received, the one warning her that Mercer was never the top of the food chain, the one suggesting that some systems protect themselves by sacrificing pieces. Keep investigating. We will. But you should know, there's been pushback, pressure from certain quarters to wrap this up. Declare victory, move on. Pressure from whom? The kind of pressure that doesn't leave fingerprints. The kind where suddenly budget allocations get reviewed and personnel assignments get questioned and investigations that seem like priorities become afterthoughts. The system protecting itself. Always. She ended the call, sat in the silence of her office, looked out the window at Tallahassee's skyline, the Capitol building, the legislative chambers, the networks of power that operated according to rules that had nothing to do with law and everything to do with survival. 6 months of work, one judge removed, one bailiff demoted, one prosecutor exiled, and somewhere above all of them, the people who had enabled everything remained untouched. Was it enough? It was never enough. Justice was never complete. Accountability was never total. The system bent but didn't break, reformed but didn't transform, accepted sacrifices while protecting the structures that had made those sacrifices necessary. But there was another way to measure progress. 400 defendants had received excessive sentences in Mercer's court. Some of those sentences were now being reviewed. Not all. The appeals process was slow, underfunded, dependent on attorneys who took cases for free or reduced fees. But some, a few dozen so far, with more pending. Darnell Watkins had been released, the young man whose $50,000 bail had first shown Nadine the pattern. His case had been dismissed after the new judge reviewed the evidence and found insufficient grounds for trial. He'd spent 4 months in county jail, waiting for justice that had been denied by design. 4 months, 122 days, 3,000 hours stolen from a young man whose only crime had been existing in the wrong courtroom. Nadine had attended his release, had watched him walk out of the county facility into afternoon sunlight, had seen his mother embrace him on the courthouse steps, both of them crying in a way that should have been private, but had become public because cameras were always watching. He'd looked at Nadine across the crowd, recognition, gratitude, and something else, the lingering knowledge that she had been in his courtroom as a spy, observing his treatment while pretending to be his advocate. She hadn't approached him, hadn't tried to explain or apologize. Some distances couldn't be bridged, some costs couldn't be repaid. Terrence Mitchell was still in prison. That was the other side of the ledger, the side that kept Nadine awake at night. The Mitchell trial had proceeded while she documented it. The conviction had occurred while she gathered evidence. The sentence, 25 years for armed robbery, based on eyewitness testimony that she knew was unreliable, had been imposed while she waited for the right moment to reveal herself. She could have stopped it, could have revealed her identity before the verdict, could have declared a mistrial based on judicial misconduct and given Mitchell a chance at a fair hearing. She hadn't. She'd made a strategic choice, preserved the larger investigation, allowed one conviction to strengthen the case against the system. Was it the right choice? She didn't know, might never know. Mitchell's appeal was pending. The new evidence of Mercer's bias would be part of his argument, but appeals took years, and Mitchell was serving his sentence now. Today. Each day that passed was another day of freedom stolen. The mathematics of justice were never clean, never balanced, always someone paying the cost while someone else measured the benefit. If this story has you thinking about justice, real justice, not the simple kind, subscribe. Tomorrow's story explores what happens when the system fights back. The visitor arrived unannounced. Nadine's assistant knocked twice, then opened the door. "Attorney General, there's someone here to see you. She doesn't have an appointment, but she says it's urgent. Delia Vance." The name triggered memory. Court reporter, Marion County, 18 years of transcripts. The woman who had quietly provided documentation that had helped build the case. "Send her in." Delia Vance entered the office slowly. She looked older than she had 6 months ago, grayer, more tired, carrying a weight that showed in how she moved. "Attorney General, thank you for seeing me. Please sit." Nadine gestured to the chair across from her desk. "How can I help you?" Delia sat.
Took a moment to gather herself. "I retired 2 weeks after Mercer's suspension. 30 years of pension, health benefits, a cabin in the Panhandle where no one knows what I spent my career documenting. I heard you earned the rest." Did I? The question wasn't rhetorical. I sat in that courtroom for 18 years. 18 years of typing every word, every ruling, every comment that should have been challenged but wasn't. I documented everything, and I did nothing. You provided transcripts that helped build the case. Without your records, my records. Delia's laugh was hollow. My records sat in filing cabinets for years. Anyone could have accessed them. Anyone could have seen what I saw. But no one looked. Because looking meant doing something.
And doing something meant risking something. She leaned forward. "I came here to tell you what I've learned. Not about the legal case. You know more about that than I do. About the system. About what happens when you try to change something that doesn't want to change." "I'm listening." "The system doesn't change. It adapts. It finds new ways to do old things. New faces to sit on old benches and make old decisions." Her voice was bitter but clear. "You removed one judge. There are 400 more in this state. How many of them operate the same way? How many have assistants who coordinate with prosecutors? How many have bailiffs who intimidate defense counsel? How many have clerks who lose filings from attorneys they don't like? I can't investigate every judge in Florida. No, you can't. That's my point." Delia stood, walked to the window, looked out at the capital city. The people who matter, the ones with real power, they're watching what happens to Mercer, learning from it, not learning to be better, learning to be more careful, learning how to do the same things without leaving evidence, learning how to protect themselves from the next attorney general who decides to go undercover. She turned back to Nadine. You did something important. You removed a bad judge. You documented a pattern. You made people pay attention, at least for a while, but you didn't change the system. You can't change the system. The system is designed to survive people like you, to absorb challenges, to adapt and continue. Then what was the point? The point? Delia considered the question. The point is that Darnell Watkins is free, that some defendants who should have gotten fair trials might actually get them now, that someone, somewhere, will think twice before doing what Mercer did because they saw what happened to him. That doesn't sound like nothing. It isn't nothing, it's just not everything. Delia moved toward the door. I wanted you to know that. Wanted you to understand that what you did mattered, even if it didn't matter enough. Even if the system keeps doing what systems do. She paused at the door. One more thing. The governor's office, the connection you couldn't prove. You should know that it's real. I saw things, heard things.
People who visited Mercer's chambers and never signed the visitor log. Phone calls that were never documented. The protection was real, and it came from high up. Can you testify to that? I can tell you what I observed. Whether that constitutes legal testimony, that's for lawyers to decide. She smiled, faintly. But I kept my own records, not official transcripts. Personal notes, dates, times, names I recognized. She reached into her bag, pulled out a thick envelope. This is a copy. The original is in a safe place. Make of it what you can. She placed the envelope on the chair by the door, left without waiting for a response. The door closed softly behind her. Nadine sat in the silence that followed. The envelope waited. Inside it, potentially, was the evidence that could extend the investigation upward, could expose the protection that had allowed Mercer to operate for 22 years, could threaten people with real power rather than appointed judges who served at others' pleasure. Or it could be nothing. Notes that didn't quite connect. Observations that couldn't be corroborated. The kind of evidence that prosecutors looked at, considered, and ultimately filed away because it wasn't enough, would never be enough. She picked up the envelope, opened it, began to read. The notes were meticulous. Dates, times, names. Delia Vance had spent 18 years documenting everything, not just the official transcripts, but the unofficial patterns. Who visited, when they visited, what happened afterward. The pattern emerged slowly. Phone calls from the governor's scheduling office, followed by favorable rulings on cases involving donors. Visits from legislative staff, followed by dismissed complaints. A web of connections that linked the courtroom to the Capitol through threads that were individually innocent but collectively damning. Would it be enough for prosecution? Probably not. The connections were circumstantial. The beneficiaries had maintained careful distance. The system's insulation had worked as designed, but it would be enough for something else. For documentation. For the record. For the next Attorney General who inherited the file and decided to keep investigating. For the slow accumulation of evidence that might, eventually, reach the point where even careful people made mistakes. She closed the envelope, added it to the file, continued the work that was never finished. 3 weeks later, the text message arrived. The governor would like to meet. 6 words. No sender identification. No context. Just an invitation, or a warning, from someone with enough access to get her personal number. She showed the message to Marcus. Trap? Probably reconnaissance. They want to know what you know, what you're willing to pursue, whether you can be managed. Managed. Bought. Threatened, persuaded. Whatever works. He studied the phone. The question is whether meeting serves your interests or theirs. If I don't meet, I learn nothing. If you do meet, they learn everything. Your body language, your tells, how you respond to pressure. Information flows both ways in these conversations. Nadine considered the options. The meeting was risk, but so was avoidance, and she hadn't built a career by playing safe. I'll take the meeting. You sure? The governor, or whoever sent this, wants to know if I'm a threat. I want to know who I'm threatening. Seems like we both have reasons to be in the same room. She typed a response. When and where? The reply came within seconds. Tomorrow. Governor's residence. 8 p.m. Come alone. You. The governor's residence occupied a historic estate on the outskirts of Tallahassee. Iron gates. Security personnel who checked IDs against lists. The architecture of power that reminded visitors they were entering someone else's territory. Nadine arrived at 7:58, drove her own car, came alone as instructed but wearing a wire that fed to a recorder in her vehicle, the kind of precaution that any experienced prosecutor would take to a meeting with potential adversaries. The aide who met her at the door was young, polished, forgettable, the kind of staff member chosen specifically to leave no impression. Attorney General, the governor is waiting in the study. This way. The study was exactly what she expected. Leather chairs, bookshelves lined with titles that had been selected for appearance rather than content. A desk that dominated the room like a throne, and behind it, Governor Raymond Caldwell. 61 years old, 2 terms in office, political survivor who had navigated crises that would have destroyed lesser careers. His face was familiar from campaign materials and press conferences, the practiced smile, the careful presentation. In person, the impression was different, sharper, more calculated. Attorney General Okafor, thank you for coming. Governor? Please, sit. He gestured to a chair across from his desk. The positioning was deliberate. He remained elevated. She sat lower. The geometry of power. I wanted to speak with you privately, without staff, without press. Just 2 people who serve the same state, trying to understand each other. I appreciate the opportunity. Do you? His smile didn't waver, but something in his eyes shifted. Most people in your position would have ignored my invitation, would have assumed it was some kind of trap, would have lawyered up and demanded formal channels. I'm not most people. No, you're not. He leaned back in his chair. You went undercover in a county courthouse, spent 6 weeks pretending to be someone you weren't, built a case that removed a judge who had served for 22 years. That takes a certain kind of commitment. It takes evidence. The commitment was already there. Evidence. He repeated the word like he was testing its weight. You found evidence of a pattern. Statistical evidence, documentary evidence, the kind of evidence that prosecutors love because it looks impressive in court filings. The kind of evidence that convinced Chief Judge Blackwood to issue immediate suspension. Eleanor Blackwood is a careful jurist. She followed the law, made the appropriate ruling based on what was presented to her. He paused. But law isn't the only consideration in situations like this. There's also politics. Perception. The question of whether removing one judge actually changes anything or just creates the appearance of accountability while the underlying structures remain untouched. Is that what you wanted to discuss? Underlying structures? I wanted to discuss reality. He stood, walked to the window. The pose was practiced, statesman gazing at the state he governed, concerned for its welfare. Judge Mercer served for 22 years. In that time, he handled thousands of cases. He made decisions that people disagreed with. He had a particular style that some attorneys found difficult. None of that makes him a civil rights violator. The 68% bail disparity does. Statistical anomaly, subject to interpretation. The emails coordinating with prosecutors do. Routine communication, standard practice in every courthouse in America. The transcripts where he told defendants he could predict their futures based on their zip codes do. The governor turned from the window. His expression had shifted again, less performance, more genuine. Attorney General, let me be direct with you. The Mercer situation was handled badly. I acknowledge that. Mistakes were made. People who should have intervened earlier didn't intervene. The system failed. The system didn't fail. The system worked exactly as designed. That's your interpretation. That's the evidence. He returned to his desk. sat down. The geometry reasserted itself. Power positions, controlled territory. What do you want? I want to know who protected Mercer for 22 years. I want to know why 3 complaints to the Judicial Qualifications Commission were dismissed within 48 hours. I want to know who made phone calls and who received them and who decided that a judge with documented bias should remain on the bench. Those are significant questions. Questions that might lead to significant answers, I'm aware. Answers that might implicate people, important people, people with the ability to make your career very difficult. Is that a threat, Governor? It's an observation, a realistic assessment of how things work. He spread his hands. You're a talented attorney. You've accomplished something significant. But talent only takes you so far. At some point you need allies, friends, people who can open doors that would otherwise remain closed. And in exchange for those allies, those friends, those open doors, what exactly would be expected? Nothing unreasonable. Focus on the cases that matter, the ones where justice can actually be served. Let the other matters, the ones that lead nowhere, that implicate people who can't be touched, let those matters resolve themselves. You're asking me to stop investigating. I'm asking you to be realistic about what investigations can accomplish. Mercer is facing federal charges. His career is over. The system has been reformed. New procedures, new oversight, new accountability mechanisms. What more do you want? The truth. The truth. He shook his head. The truth is that power protects itself, always has, always will. You can tilt at that windmill for the rest of your career and accomplish nothing except making enemies of people you'd rather have as friends. Or you can accept that some battles aren't worth fighting and focus your energy on battles you can actually win. I appreciate your candor, Governor, but I think we have different definitions of winning. She stood. The meeting was over, had been over from the moment he tried to bargain rather than deny. Thank you for your time. I'll see myself out. Attorney General? His voice stopped her at the door. I meant what I said about enemies, not as a threat, as advice. The people who protected Mercer, the people who benefit from systems like the one you uncovered, they don't forget, they don't forgive, and they have very long memories. So do I. She walked out. Through the hallway, past the aide who'd escorted her in, through the gates that opened automatically, into her car where the recorder had captured every word. The conversation would never be used in court. It wasn't evidence of crimes, just evidence of how power worked, how bargains were offered, how threats were disguised as advice, but it would be added to the file. Another piece of documentation, another data point in an investigation that would continue as long as she had the authority to pursue it. The governor was right about one thing. Some battles couldn't be won. Some systems protected themselves too effectively to ever be fully dismantled. But battles weren't the only measure of progress. Sometimes what mattered was the documentation, the record, the accumulated evidence that made denial progressively harder. Sometimes what mattered was simply refusing to stop. The Marion County Courthouse stood unchanged. Same limestone facade, same dying grass, same wheezing air conditioning that had been promising to fail for decades. Nadine returned 1 year after her undercover investigation had begun. Not as a contract public defender, not as the Attorney General conducting official business. Just a woman in professional clothes, walking through doors she'd walked through 100 times, seeing the building differently now that she understood what it contained. The security checkpoint was the same. Different officers, but the same bored processing of visitors. The metal detectors still beeped at random intervals. No one checked IDs carefully. The system existed to create the appearance of security without actually providing it. She walked through, collected her briefcase from the X-ray conveyor, continued toward the elevator bank. Room 112 still occupied the basement. The same water stains on the walls, the same buzzing fluorescent lights. But a different clerk sat at the front desk now. Renata Voss had been terminated after the filing deletion was traced to her login credentials. The new clerk was younger, less weathered by years of complicity. "Can I help you?" "Just visiting. I used to work here." The clerk's expression shifted. Recognition, maybe. The Attorney General who had gone undercover in this very building. The story had circulated through courthouse gossip for months. "We've made changes since then. New procedures. New oversight." "I know." She walked past the clerk, down the hallway, past offices where contract public defenders still worked on cases that still mattered to people who still couldn't afford private counsel. The work continued, would always continue. The system processed defendants the same way it always had, different faces behind the benches, different names on the dockets, but the same fundamental machinery turning the same gears. The elevator took her to the third floor. Courtroom 4B was in session, a different judge now, a visiting jurist assigned while permanent replacement was debated. The nameplate beside the door had been removed. The brass holes where screws had held it were visible, like wounds that hadn't fully healed. She didn't enter, just stood in the hallway, watched attorneys and defendants and families move through the space where she'd spent 6 weeks documenting injustice. "Attorney General?" The voice came from behind her. She turned. Darnell Watkins stood in the hallway, older than she remembered, not by years but by experience. The young man who'd been held on $50,000 bail for a first offense looked different now. More careful, more guarded. "Mr. Watkins, I thought I recognized you." He shifted his weight, uncertain about the encounter. "I work here now, courthouse maintenance. It's not much, but they were hiring and I needed something." "You work in the building where you were wrongly detained?" "I figure it's better than avoiding it. Better than letting them keep me scared of my own courthouse." He almost smiled. "Plus, I know where all the problems are. The broken fixtures, the leaks, the things nobody else notices." "That sounds right." They stood in silence for a moment, the awkwardness of two people connected by circumstance rather than choice. "I never thanked you," he said finally, "for what you did. I know you were investigating, not really representing me. But what happened in my hearing, that was real. You actually tried to help." "I did what I could. It wasn't enough." "It was something." He glanced toward courtroom 4B. "Most people who walk through here, they don't see anything wrong. Don't want to see. You saw. You did something. That matters." "Does it?" "To me it does." He reached into his pocket, pulled out a folded piece of newspaper. "I kept this from when the verdict came down against Judge Mercer. Read it probably 100 times. He unfolded the paper, handed it to her. The headline, "Former Circuit Judge Convicted of Civil Rights Violations." She hadn't seen this article, had been traveling when the jury returned its verdict, had received the news secondhand, in text messages and phone calls that felt anticlimactic after the years of investigation. Guilty on 16 counts. The words filled the page. The conviction hadn't been total. 2 counts had resulted in acquittal, the jury apparently unconvinced on cases where evidence was thinnest. But 16 counts. 16 instances of constitutional violation formally acknowledged by 12 citizens who'd reviewed the evidence and found it compelling. Mercer's sentencing was scheduled for next month. The federal guidelines suggested 12 to 15 years. His attorneys were still filing motions, arguing for leniency based on years of public service. The system's self-protection instinct, working even in defeat. 12 years. Darnell's voice was quiet. "That's what the papers say he'll probably get. 12 years for what he did to hundreds of people." "Is that enough?" "No." The word came without hesitation. "But it's something. More than I thought would ever happen. More than most people like me ever get." She handed back the clipping. He refolded it carefully, returned it to his pocket. "I should get back to work. Supervisor doesn't like us standing around." He started to turn. Stopped. "Can I ask you something?" "Of course." "Why'd you do it? Go undercover, I mean. You were already the Attorney General. You could have just sent investigators. Could have built the case from behind your desk. Why come here yourself?" She considered the question. Had asked it herself many times. Because data isn't testimony. Statistics aren't experience. I needed to understand what it felt like. Being in that courtroom, watching the system work the way it worked, being treated the way you were treated. She paused. And maybe I needed to remember why I became a lawyer in the first place, why any of it matters. Did it help, remembering? I think so, yes. He nodded. The answer seemed to satisfy something. Good luck, Attorney General, whatever comes next. He walked away, back to the maintenance work that kept the courthouse functioning, back to the daily labor of existing in a building that had once held him unjustly. Nadine watched him go, then turned back toward the elevator, toward the exit, toward whatever came next. The investigation continued, not the Mercer investigation that had concluded with his conviction and pending sentencing, but the larger investigation, the one that followed threads from Marion County to Tallahassee to wherever they led, the one that documented patterns rather than individuals, the one that might never produce convictions but would produce records that couldn't be destroyed. The governor's connection remained unproven, not disproven, just unproven, the kind of truth that existed without being admissible, the kind of knowledge that shaped behavior without providing remedy. Other judges were being watched now, other courtrooms documented. The DOJ pattern or practice investigation had expanded beyond the Fifth Circuit, finding echoes of what had happened in Marion County in jurisdictions across the state. Nothing as blatant as Mercer, nothing with the same statistical signature or documented coordination, but patterns, tendencies, the quiet accumulation of bias that didn't announce itself but shaped outcomes nonetheless. The system was adapting, learning, becoming more careful without becoming more just. But the documentation continued. The records accumulated. And somewhere in those records, perhaps, was the evidence that would eventually matter. The thread that would eventually be pulled. The case that would eventually be built. 6 months after Mercer's conviction, Nadine received a package at her office. No return address, no explanation. Just a manila envelope containing a single photograph and a handwritten note. The photograph showed a meeting room, conference table, 5 people seated around it, faces partially visible, positions suggesting hierarchy. One of the faces she recognized immediately, the governor. The others were unfamiliar, but the setting suggested significance. The timestamp in the corner read 3 years ago, predating her investigation by more than a year. The note contained 3 words, "Keep looking, they know." She stared at the photograph for a long time. The people in it, the implications of their presence together, the suggestion that this was evidence of something larger than what she'd already uncovered. Then she added it to the file. One more document in an investigation that would continue as long as she had breath and authority to pursue it. The Marion County Courthouse stood unchanged. Same limestone facade, same dying grass, same institutional indifference to the people it processed. But inside, something had shifted, not transformed. The system didn't transform, but shifted. Slightly, incrementally. The way systems shift when they absorb challenges and adapt to survive. New procedures were in place. Bail decisions were reviewed more carefully. Case assignments were tracked more transparently. The obvious excesses had been curtailed, not eliminated, but curtailed. But it wasn't justice, not complete justice, not the transformation that activists dreamed of and defendants deserved. But it was something. And sometimes, in a system designed to resist change, something was the best you could hope for, the foundation on which future change might be built, the documentation that future advocates might use. Nadine Okafor had gone undercover to expose a pattern. She had exposed it, had documented it, had seen one judge convicted and others put on notice. The system remained, would always remain, would always protect itself through adaptation rather than transformation. But the documentation existed now. The precedent had been set. The possibility of accountability had been demonstrated. even if accountability itself remained incomplete. And somewhere, in a maintenance closet in the Marion County Courthouse, a young man named Darnell Watkins kept a newspaper clipping that reminded him justice was possible. Not guaranteed, not complete, but possible. That had to be enough. For now. The story of Nadine Okafor is not a fairy tale where justice triumphs completely and the wicked are properly punished. It is a story about reality, where justice arrives late, remains incomplete, and always demands a price. The first lesson: systems do not change themselves. For 22 years, Judge Mercer sat on the bench. Hundreds of people knew he was biased, but no one spoke up. The system protects itself by making everyone fear the consequences of telling the truth. The silence of the majority is the fuel that feeds injustice. The second lesson: documentation is a weapon. Nadine did not win with words or emotions. She won with numbers, transcripts, emails, timestamps. In a world where power can distort the truth, carefully preserved evidence is the only thing that cannot be denied. The third lesson: justice is never perfect, but still worth pursuing. Mercer was convicted, but those who protected him remain free. Terrence Mitchell is still in prison. Lockhart got a new job in Tampa. The system sacrificed a pawn to protect more important pieces, but Darnell Watkins is free. Other judges started being more careful. Sometimes, something is all we can achieve, and that is still a victory. The final lesson: being underestimated is your greatest advantage. Mercer looked at Nadine and saw a black female public defender not worth his attention. That arrogance was exactly what destroyed him.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.